Matter of Piraeus International Incorporated Costs. April 11, 2022. When an agency takes corrective action in response to a protest, our office may recommend reimbursement of protest costs if, based on the record, we determined that the agency unduly delayed taking corrective action in the face of a clearly meritorious protest, thereby causing the protester to expend unnecessary time and resources to make further use of the protest process to obtain relief. As a general rule, as long as an agency takes corrective action in response to a protest by the due date of the agency report, we regard such action as prompt and will not grant a request to recommend reimbursement of costs. A protest is clearly meritorious where it is not a close question. Where a reasonable inquiry by the agency into the protest allegations would have revealed facts showing the absence of a defensible legal position. The fact that an agency decides to take corrective action does not necessarily establish that the protest was clearly meritorious, and that the agency did not have a defensible legal position. Generally, a successful protester should be reimbursed its incurred costs with respect to all the issues pursued, not merely those upon which it has prevailed. In appropriate cases, we have limited our recommendation for the award of protest costs where a part of those costs is allocable to an unsuccessful protest issue that is so clearly severable from the successful issues as to essentially constitute a separate protest. In making this determination, we consider, among other things, the extent to which the claims are interrelated or intertwined, whether the successful and unsuccessful claims share a common core set of facts, are based on related legal theories, or are otherwise not readily severable. As our office has explained, we will not recommend reimbursement of protest costs for arguments that were not timely raised. In this regard, our office will recommend that an agency reimburse protest costs where the agency unduly delays taking corrective action in response to an argument that was clearly meritorious. In essence, a finding by our office that an argument was clearly meritorious means that we would have sustained the protest had we issued a decision on the merits, and that such a decision would not have been a close call. A protest argument that was dismissed, therefore, cannot be viewed as clearly meritorious, because there is no possibility that our office would have sustained a protest ground that was dismissed as untimely.